says, we are not going to go to court. We are going to try and resolve this dispute between us by way of negotiation. And if we fail in that negotiation, then I can no longer engage you, Juliette, to be your lawyer. So I am only engaged as settlement counsel. I therefore don't have to have two hats on. I don't have to have one eye on litigation and therefore keep my eye on litigation when I'm negotiating, which is what happens in your traditional world. And therefore the negotiation to some extent is compromised because I've got to keep maybe a few cards still in the pack. I have to be very careful about how I choreograph any sort of settlement conference because I've still got to, I don't necessarily trust the other party that they are here to resolve. Whereas if everybody puts their money where their mouth is and sits down and says, yes, I'm going to sign this piece of paper that says I'm not going to go to court, that changes the whole environment in which the negotiation takes place. And it means the two lawyers work together to assist the two parties to get there.
It's 22 minutes past 2. Our guest on Afternoons on 666 ABC Canberra is Juliette Ford. She is a lawyer, well, a director, I should say, with Consensus Family Lawyers here in Canberra. We're talking about collaborative law, a different approach to family law. When we've been through this process and hopefully the quartet can get to an agreed, amicable, respectful outcome, is that automatically I mean, that doesn't wind the relationship up. What happens then? A recommendation or something goes to the family law court or whatever?
At the end of the process, when an agreement is reached, and interestingly enough, I do say when, because in all the cases that I have done, I think I've had something like a 98% success rate, which is extraordinary when you think about the lot of debate that goes on about what happens if you don't sign, if you sign the contract and the agreement falls over. From my experience, focusing upon that 2% and to say, well, that's the reason why we don't sign the contract is crazy. Mm-hmm. Because for all those people that have signed the contract, the agreement they've reached, what I have observed is that agreement has been a lot more stickable, if you like to use it. Word doesn't exist. Your previous,
I don't know that Bruce Moore would be happy with that.
Your previous client would be, your previous person would be just shocked. But those agreements stay and they work. And what we do is we actually create a space where, if it is in relation to children and something falls over, there's an avenue back to go and talk about that again. In relation to financial arrangements, you know, the agreements we have reached in collaborative law have been some of the most interesting, out-of-the-box, more flexible, different kind of agreements than what you would do or discuss in any kind of traditional negotiation. And so, to answer your question, Greg, the pathway for that quartet going forward has generally been a very happy one. There has been some people who still struggle, but they're not in the court system. And still, again, they're still understanding that at the end of the day, even if it is very difficult to continue to communicate with their ex-partner in relation to something, it is still better to work on that communication rather than what is perceived to be the quick fix of making an application to the court, which at the end of the day doesn't really benefit anyone, and most particularly the children, who may not be directly involved in the proceedings but are always aware of the fact that their mum and dad may be arguing about something.
Has it been happening for not long enough, Juliette, that you can look at the long-term post everything settled and kids not being this sort of ball in a tennis match or whatever else, that there's an agreed outcome which is designed to be the best for the kids? Have you been able to get sort of some data or evidence or whatever else that kids come through the process better as a result of the whole process, I guess, being respectful?
We haven't undertaken any specific research in relation to that question, but I suppose from the cases that I've done and the cases that my colleagues have conducted, it has been clear that when you set some road rules right at the beginning for the parents as to what their commitments are going to be, and you talk about what they aim for, and you talk about very simple things like, how do you want it to be at your child's 21st? Do you want it to be an issue for your children when they're turning 21 as to who they invite or how they invite? If you ask them, do they want the invitation list for the wedding to be an issue? And you actually ask those questions in one of those very first meetings, and you keep going back to that as a touchstone, and then you build that in going forward, that is what creates the conscientious commitment to the arrangements for the children then continuing to be negotiated and it being a much more effective regime for the children. What is clear, and this is where the stats are, Greg, is that in relation to the children that have been the subject of ongoing adversarial proceedings and repeated proceedings for years and years and years, the effect on those children is a negative one.
Right.
And so if you turn that around and you look at, all right, how do we manage what is the difficulties we have? How do we create and work on what's called in these circles a parental alliance? Then that's where you get really successful traction.
A listener has asked, and that all sounds very, very good, because there's another element to these proceedings which you can't overlook. A listener asked about the comparative costs of standard proceedings versus collaborative law processes, Juliette.
It's a very, very good question. And you have to be very careful that you compare apples with apples. And what I talk about when I'm talking to people is a triangle. And if you visualise a triangle in your mind, many people who separate might fall into the top bit of the triangle, and therefore they don't need much support from outside resources. And therefore for them, their settlement won't cost them a lot. As you move down the triangle, the base of the triangle gets wider. The more resources those people, the more help those people may need to get to a resolution, either from way of lawyers, counsellors, financial information that may be relevant for them to help them with respect to their options to settlement. The answer to the question is this: if you compared a case that's likely to be litigated, and they're the sorts of cases that generally fall into the collaborative space, then collaboration is generally much more cost effective. And the other point I often make to clients is this: the money you do spend in collaboration is a positive spend.
Yes.
It's not a negative spend. You're not forced to spend money engaging your lawyer to write the letter you don't think needs to be written. You're not forced to engage your lawyer to draft an affidavit which will be filed in the court and which may or may not be used in a proceeding you didn't want to embark upon. So all the money you do spend on your lawyer is a positive spend in that sense, because it's constructive towards outcome. Most of the engagement of your lawyer occurs in meetings, so you actually see what they're doing. And you're working with them. You're working with them, so you can actually see how your dollars are being spent. I have not had one query about my accounts in the collaborative space. And what's interesting is when they've ended, I've had thanks from the other party to me, saying, thanks so much in you two helping us get to this point.
It's got to be a very pleasant way to perform your role, as opposed to that very antagonistic and negative approach to things, Juliette.
From my background, and I've practiced in family law now for nearly 20 years, I have to say the work where I've had the most satisfaction has been those cases where I've been able to assist people to reach resolution. And now practicing in the collaborative world, that has been a much more satisfying area of work for me. And when you're doing something where you can see that people can see that there is a roadmap to resolution, and you can see that although this is still hard, because I wouldn't ever say to anybody that doing something collaboratively is necessarily easy, the outcome for the people involved is generally much more effective.
All right. Juliette, time for us to finish our conversation. It's 2:30. Thank you so much for coming in. Juliette Ford is a lawyer with Consensus Family Lawyers here in Canberra, talking about collaborative law. I imagine if people want to find out more, they could put those two words in a search engine and start to...
They certainly can, Greg.
All right,
thank
Julie.
you very much for having this conversation this afternoon.
My great pleasure. Thank you for your company, Juliette.